Joining us for this Idaho Reports Web Extra, we have Jason Risch of Risch Pisgah Law and Policy, Senator Mary Ann Jordan, and Betsy Russell of the Spokesman Review. So we have had a lot happen nationally, but a lot going on in Idaho too. Betsy, can you update us on where we are with the grocery tax veto lawsuit?
Absolutely. Today is the day that most of the briefs were due in the case from the various sides, and there are more sides now than we started off with.
Right, it's not just Representative Ron Nate versus the governor at this point.
Right, and of course the original filing was Ron Nate and 29 other legislators versus the governor, or versus the Secretary of State in his official capacity, because they want him to say this is a law, it wasn't vetoed. The governor has been approved to intervene and has filed his own arguments. The leadership from both parties in the Senate, including Senator Jordan, has petitioned and been granted permission to file their own arguments, and theirs are being limited to a specific question about the constitutionality of the bill.
And can you explain that real quick for people who aren't familiar with the Constitution question of the
Sure.
bill itself, not the veto, but the bill?
Right, so the Constitution says that measures that raise revenue are required to start in the House of Representatives. And in this case, we have a bill that started out in the House as an income tax cut bill. It got sent over to the Senate amended it, transformed it completely into an entirely different bill, and now it was a bill to repeal the sales tax from groceries. They passed it, sent it back to the House approved it. The question is, does that mean, because the language in the bill didn't originate in the House, that there was some constitutional defect in that process? And the Senate leadership is arguing strenuously that there's not, but the governor is offering some arguments that perhaps there is, and that if the legislators who filed this lawsuit want a very strict constructionist reading of the words in the Constitution, which is the basis on which they're attempting to overturn the veto, that same analysis should be applied to this issue.
Jason, I'm curious the legal perspective. For people watching who aren't familiar, this isn't just a normal lawsuit. Like, I am suing you for change.
Right. No, this is far from that. This was something that, and because it is a very important issue, it does go straight to our Supreme Court. So you're seeing these battles at the highest level of our jurisprudence. So we're not going through magistrate or district court to get to the Supreme Court. This is right before our Supreme Court justices, as well it should be, because it's an important issue. But it's from a lawyer standpoint, it is fascinating. It's almost like a law school question, because it is the suit itself really was placing the concept of stare decisis, which is, you know, the Supreme Court interprets laws and they make decisions, they hand those down, and those decisions are binding, and they don't just change those because they don't like them, or because there's a very high standard for reversing stare decisis. But on the other hand, it's right smack dab up against the very plain, unambiguous language of our Constitution that says 10 days after adjournment, not 10 days after presentment. And now we know that's been watered down through case law over time, but it is fascinating from a legal standpoint to see those two theories sort of clashing head on.
And there are ramifications too if the court agrees that the bill itself was not constitutional, because the Senate regularly changes tax policy that started in the House. In some ways, you could argue it's the only way the Senate really gets a say in tax policy.
Exactly, and that's it comes from the Constitution. Our Constitution states that the revenue-raising bills start in the House. The problem is, I think you could also start with a sort of a creative, this is sort of the lawyer in me coming out, but was this really raising revenue, or was this cutting revenue, right? Reducing revenue? So you have that argument, but that issue has come up before in a couple of cases before the Supreme Court, back in 1974 in a case, Worthington, I believe it was called. And then it was recently, actually in 2005, it came up again with a lot of members of our court that are there today, and they let it stand. And it'll be interesting to see how this all does play out. But it is absolutely fundamental to the way the Idaho State Senate does business, and if the Supreme Court should wander into that, I think there's a lot of questions about the separation of the three branches as well.
Senator, I'm curious your take on this, because you are someone who supported the repeal of the grocery tax bill. Why not just wait and try to pass the legislation under a new governor, especially after 3 of the 4 Republican candidates for governor, and I think probably the 4th one too, would agree that they want to repeal the grocery tax? Why not just try again in 2019?
Well, the intervention on the part of the Senate leadership, both Republican and Democrat, it is a bipartisan intervention, was not to debate the merits of the veto of the grocery tax. It's to debate the governor's intervention on the process piece, right? And it is very much the thought of all of that membership that the Senate has the ability to amend bills. And we need to remember that those bills, as amended, need to be sent back to the House for an up or down vote. It doesn't just stop with an amendment in the Senate. It still needs to go back to the House to be validated or rejected. And so that the intervention was really on the process. And the process will inform what happens regardless of what the decision is on the veto of the grocery tax.
I'm curious, you mentioned the separation of powers and the balance of powers. Is this a normal push and pull between the powers of government, or is this something extraordinary?
I think this one's a little bit extraordinary, and going back to what was said a moment ago, the different arguments that have been raised by the governor in this particular the lawsuit which led to the intervention, I can completely understand the governor's attorneys and why they brought these arguments up, because as attorneys we always throw in all the arguments you can, because you never know which way a court's going to go or what a judge is going to sort of latch on to. So I do get that, but it did have some unintended consequences, I think, with bringing the Senate leadership involved. But I don't think it's necessarily, back to your question, I don't think it was necessarily a true battle of the different branches. I think it's probably more of a battle of some different ideologues within a party.
Well, I think this raises yet another question, and this is a non-lawyer question, but why does the Idaho Constitution say that tax bills have to start in the House? I mean, our House and Senate are basically identical. The House has twice as many members as the Senate, but the members represent identical districts and serve for identical terms. Why do we have that rule? And why is it important enough to be such a big factor in a process like this?
I can weigh in on that,
Yeah,
actually.
please do, because I don't know.
Surprisingly, this goes back to the foundation of our nation. Our language matches very, very similarly the United States Constitution. And by the way, the Santa Rosa case, the Santa Rosa v. Andrus, was based on a United States Supreme Court case where the exact same thing came up, where they were challenging a president's veto of a bill that came out of Congress, and it was all about the timing. And so our Constitution matches that, but the concept behind it was, when our founding fathers were getting together, the power to tax was the power to destroy. And so they wanted that power to rest with those that were closest to the people, which, as we know, the People's House being Congress, or being the House, where especially when we had different ways of having senators back then. And so that's the origin. That's why it says that.
But in Idaho, our senators, just like the members of the House, have only 2-year terms. And I know that there have been some ideas kicked around that maybe senators, to more closely mirror what happens in D.C., should have longer terms. And it's not necessarily a popular thing for members to suggest that, they have a little bit more job security. But I'm curious what your thoughts are, Senator Jordan.
Well, I think you're right on your interpretation of that, but I also think that having the entire legislature with 2-year terms doesn't lend itself to any real good long-term planning. People can't see beyond 2 years. And, folks have their hearts in the right place. They have their policy ideals that they want to bring forward, but at the end of the day, that weighs. And longer terms allow you time to work. And to affect some policy, to retain a little bit more institutional knowledge. I mean, we've seen turnovers well over 30% in any given year in the legislature, and so there's a lot of reinvention of wheels and policy and so on. It's a difficult call. I personally, I wouldn't argue with not having to run every 2 years. It's a big ask of your constituents. It's a big ask of the representatives, but it's also the system that we have, and it's what we signed up for. So, to me, if it's the kind of thing that there's a demand for it from the citizens, it's something I'd consider. It's not really high on my policy list personally.
I'm curious, too, about one of the process questions. The idea that the legislature could hold a bill for 12 days and just not deliver it to the governor. Now, in legislative rules, it says that they have to deliver the bill within 48 hours, I believe.
Well, it's a total of 5 days, but there are several different steps, and they add up to about 5 days.
Well, that's awfully complicated, Betsy. but all of that said, that's not in statute. It's not in the Constitution. Those are in the rules. The only thing that was in the Constitution was how long the governor had to decide on the veto. So conceivably, could the legislature, depending on what the Supreme Court decides, hold a bill and give the governor less time to consider it?
I think the real difficulty here is because it is the citizen legislature and it is not there all the time, that you have this space and time for the bills that come at the end of the session that are subject to either being dealt with right away or not. And if we had a situation where the leadership could call the legislature back to address just a veto, not open it up to anything else, but just address a veto, I don't think we would really have these problems. I think that it lends itself to some puzzle making in terms of dates and times and deadlines that wouldn't exist if there were the opportunity to come back to address a veto.
Jason, I'm curious if there's anything preventing the legislature from rewriting the rules and grabbing back more of the power from the executive branch.
Well, that was the entire basis of the Senator v. Andrus decision. The court struggled with the concept that the rules, even though they are very, very clear, are subject to change by the Senate. And so what the Supreme Court said was not necessarily, while the Senate has engaged in any of that tomfoolery or something, puzzle making, as you said, it's there. And the same with the statute. The legislature has the ability to change statutes. And so the Constitution is really the backstop. And the way that they got there was the Supreme Court said that the Constitution clearly, the intent was to allow the governor time to do this veto. And they even went back to the Constitutional Convention minutes from 1912, and they looked at where this timeline came from, and they looked at the discussions that were around that. And interestingly, it was 1/6 of the legislative session back then, because they only had 2 months to do the work. So they were providing the governor with 1/6 of the time to veto the bill. And then they actually shortened it up while they were in session. But that's sort of the basis for all of it. So yeah, that was definitely a concern of the court.
One last question: how much time does the governor actually need to have the bill in his or her hands to decide whether or not to veto? Because largely, it's important the actual physical signing of the bill, but a lot of it's ceremonial. The House and Senate are on the 3rd floor. They're just one story up, and the governor knows where they're debating. They have lobbyists come in and talk to them all the time. How much of this actually matters?
Don't forget, he can actually watch what's happening too through a great service that's provided to him. The video of all the activities that are happening in the legislature.
What, provided by Idaho Public Television?
That would be
What a great service! What a great service!
I think that I think your question really you can't answer that. I mean, it certainly very few things come across the governor's desk that are a surprise, but there is a lot that goes into this type of a decision to veto a bill, especially of this magnitude. So.
All right, one last thing: predictions.
For the outcome of the suit?
The outcome of the suit.
I think, I think our Supreme Court's going to take this very seriously. Our justices do a really good job of understanding what they have, and in fact, they even understand the idea of the implications this could have going back if it were retroactive. So I think you're going to see some limitations on whatever ruling comes out. My guess, if I were guessing on it, based upon the decision they handed down in the Hoffer v. Shepard case, which was the one that changed the attorney's fees, they, for the first time, realized, the first time that I know of in history, based their decision and their ruling, they sort of made it not only proactive, but they put an effective date on it. And so they gave the legislature time to make the decision to change the law, which of course you guys did. And so I think based upon, you see that and you see the conversation they had, and they realized the stare decisis, they recognized it, and so I think they're going to see the same thing here. And no matter, I think they're going to realize that they're not going to do something that's going to change history that's happened. They're going to address this bill and future bills going forward.
Senator Jordan?
As a participant, it's probably not appropriate for me to be speculating on what the outcome might be, and so I will just say that I hope that it's an outcome that we see relatively soon, and that it can inform a path forward as to how we deal with this in the future.
Very diplomatic. Betsy?
I practice.
Boy. I think it's unlikely that the court will take away the Senate's ability to amend tax bills. I don't really see that changing. I think it's a closer call on the veto. And I think it's most likely that the veto will be upheld, but if it's not, boy, the implications are big. I mean, the 6% tax that we all pay every day on our groceries, boom, would be gone. That's really significant.
All right, and just a reminder that hearing in front of the Supreme Court is on June 15th. You can follow coverage on Betsy's blog. And thanks for watching this Idaho Reports Web Extra. We will see you next week.